Record this matter is before the court as a result of the defendant's objection to entry of a proposed judgment of divorce prepared and submitted by the plaintiff. This hearing is being conducted via Zoom. Present is Attorney Maria Zagorski, representing the plaintiff, Mark Mansik. Mr. Mansik is present. In addition, Attorney Eric Chappell is present, representing the defendant, Rebecca Devout, and Ms. Devout is present. Good afternoon, everyone.
Good afternoon.
Ms. Kuhn. I'm sorry, Ms. Kuhn is also present. Ms. Kuhn is co-counsel with Mr. Chappell. Is that correct?
Yes, Your Honor.
Is that correct? Ms. Kuhn, you're co-counsel
Yes,
with
Your
Mr.
Honor.
Okay, yeah, I
I
thought
am.
so. Thank you. The court was not able to grasp what the issue and dispute was. And you've conferred with the front of the court this afternoon and have not reached an agreement. Is that correct?
There are two outstanding issues right now, Your Honor, that the part that we have not agreed on. I think we've resolved all other language issues.
What are the issues? They've not been set forth in any of the pleadings.
Well, Judge, we've been shuffling a proposed judgment back and forth. We did get the transcript. We've gone through it page by page. And as Mr. Chappell indicated, there are just two issues that we would like the court to determine. And I'm happy to start with the easy one first, Judge.
Yeah.
The parties are required to communicate by app close. I have asked that the communications be civil and respectful and that the judgment state as much. And for some reason, the defendant does not want to consent to language that would require the parties to be civil and respectful. That's the easy one.
Well, obviously that's implied. It should be civil and respectful. Mr. Chappell, who's going to respond? Mr. Chappell or Ms. Kuhn? Why?
Your Honor, I'll be happy to respond.
The words civil and respectful.
Yeah. The concern is we're creating something and putting something in a judgment of divorce where someone then has the ability to come to court and make an argument that, you know, you weren't civil, you weren't respectful, which are very subjective determinations, and therefore try to hold someone in contempt of court. It may seem unorthodox, Your Honor. We'd like to all believe that the parties are going to, you know, always be civil, always be respectful, but this is a case where we couldn't even agree on what the definition of summer meant. So the concern is that it will just be one more avenue for Mr. Mansik to come in and say, I don't think you're being civil. I don't think you're being respectful. And then the court has to determine what those terms actually are.
Well, I think this court can use common sense to determine whether something is civil and respectful or not. I don't think it requires a legal determination or judicial determination. It's simply common sense.
Yeah. And understand that would be the standard always, Your Honor. We're just trying to avoid avenues where it will create further litigation.
Well, perhaps the best way to avoid that is to spell it out. So yes, the court will approve putting the words civil and respectful communication by app close.
Thank you, Judge. The other issue is as to custody and parenting time, and I'm sure you have a copy of the transcript in the file. You'll recall this was a little unorthodox. The parties wanted to get divorced and they were waiting for a report and recommendations from Dr. Wooten. And for that reason, we put an agreement on the record making custody and parenting time subject to Dr. Wooten's report and recommendations. That if Dr. Wooten issued a report or made recommendations, that either party could come back and that report would constitute proper cause or a change in circumstance, and either party could ask for this court to make a different determination about custody and parenting time other than joint, which is what they were exercising. Initially, defendant's counsel wanted the judgment to say that the custody and parenting time were temporary and without prejudice. And I was uncomfortable with the word temporary because I didn't think a judgment could say that custody and parenting time were temporary, but we ordered the transcript and counsel was right. The agreement was that custody and parenting time would be temporary and without prejudice. Today, counsel is asking to insert that custody and parenting time are reserved. And I take exception to a judgment of divorce reserving custody and parenting time. I think a judgment of divorce has to decide custody and parenting time. So we looked at the transcript, and the basis for their use of the term reserved was your honor's use of it when you called the case and and announced that there was a settlement, you stated, and this is at page 4 of the transcript at the bottom, Mr. Godfrey has informed the court that the parties have reached an agreement on all outstanding issues with the exception of custody and parenting time and wish to reserve that issue until receipt of Dr. Wooten's custody and parenting time evaluation. Is that correct, Ms. Zagorski? I said yes. Ms. Devout's counsel said yes. And then Mr. Godfrey put the agreement on the record, and he said custody and parenting time are temporary and pending further order of the court without prejudice. That is the language that the parties approved, temporary and without prejudice. The court's use of the word reservation, or that it was reserved, I don't think was intended to bind the parties. And my client didn't intend for that issue to be reserved, nor did I, even though I did say, yes, Your Honor. And so the argument is whether custody and parenting time are reserved or temporary and without prejudice.
Well, perhaps the court inappropriately used the word reserved. I just knew that there was not a full and final agreement on custody and parenting time. So I think it's more appropriate that the judgment provided as temporary and without prejudice.
Thank you.
So in other words, when Dr. Wooten, if he submits his report, the parties can come back before this court.
Well, and the problem with that, Your Honor, is that's not the limit of what the parties agreed to. So now we're going to have to get into other language because Mr. Godfrey also made it clear, and this is why it was reserved, and this is why we think that the words are important. Mr. Godfrey made very clear on page 5 of the transcript that you could come back in for a change of circumstances for Dr. Wooten's report, okay? In addition, if you look at pages 17, 18, and 19, neither party is prevented from bringing up matters or actions or acts that they think is important that predates this agreement. That's why reservation is important. If we don't have the words reserve in there, then we need to include the language in there that everything is open. Because here's why we believe it's important to the plaintiff. We're going to hear an argument down the road that, once a motion to modify is filed, because there is one coming, that there's certain things that you can include and there's certain things you can't include. So the reserve language, which was what the court asked at the very beginning, signifies that it's open, it's wide open.
The problem with, I'm sorry.
And we don't want to limit, anyone's consideration of what occurs just based upon Dr. Wooten's report.
The problem with Mr. Chappell's argument, Your Honor, is that I have approved language that says the parties stipulate and agree that when Dr. Richard Wooten's report and recommendations are issued, that Dr. Wooten's report is sufficient and adequate grounds for either party to seek a modification of parenting time or custody. Accordingly, this judgment shall not operate to stop either party from raising any issue that predates the judgment of divorce as part of a party's request to change custody or modify parenting time. So Mr. Chappell's requested language is already in there. It was in my original draft. I just don't think that the custody and parenting time provision should say reserved because this court used the word reserved when that's not what the parties agreed.
But that was the predicate of the agreement. It was the first thing we said when we came into court.
And
That's what the court said. That's what the court said.
But Judge, we confirmed that that's what our intent was.
the clients did not.
Well, they were next to us. I mean, it's hard to say that the clients didn't confirm it when they're sitting right next to us and we're speaking on their behalf.
I don't, Judge, I don't think that you were speaking with any intent to bind the parties. You were calling the case and introducing what you understood to be the situation. And then Mr. Godfrey read the agreement into the record and the parties confirmed their agreement.
Your Honor, do you have the transcript by chance?
Yes, I do. And I think I'm gonna have the parties brief this issue. I'm asked to look at page 5 and 17, 18, 19. I'm trying to grasp it. This court did not play any part in the negotiations, the agreement. That was Attorney Godfrey. Perhaps you should confer with Attorney Godfrey so he clarify what his recommendation was, because I believe the parties adopted and accepted the recommendation of mediator Godfrey.
Correct, Your Honor, and that's what you stated. You stated Mr. Godfrey has informed the court that the parties have reached an agreement on all outstanding issues with the exception of custody and parenting time and wish to reserve that issue until receipt of Dr. Wooten's custody and parenting time evaluation. Is that correct, Ms. Zagorski? Ms. Zagorski says yes. The court, is that correct, Ms. Kuhn and Mr. Chappell? We say yes. The court says, okay. So I mean, that was the basis. And now the problem is this judgment has been sitting here and hasn't been entered, and we have Dr. Wooten's report, and I'm waiting to file a motion, and I can't even file a motion, and I don't want to hear opposing counsel then make the argument, well, you've had Dr. Wooten's report now for so long, so it's not a proper change. I mean, this is just all getting so backlogged because the judgment hasn't been entered. And I think the reservation language is very important because that's exactly what we did, Your Honor. And that's what Mr. Godfrey had stated to you. And you asked us that exact question. And we said, yes, Your Honor, that is our agreement. That is our understanding. So I think it's just ingenuous to go backwards and say, well, our clients didn't state it. Sure they did. When we questioned them at the end, if this was their agreement, they absolutely did. And when we make a statement to the court stating, yes, this is our agreement, and our clients are right next to us, we've conferred with our clients. And I would think that the clients would bring it to the court's attention if the attorneys aren't being honest and forthright and haven't conferred with the clients and haven't represented properly. The court we know. So I think that the argument that that's not what we agreed on when we affirmatively stated to the court that's what we agreed on is not, it's being made, and it's very clear that the transcript states that we did in fact.
What if the judgment included the following language that the custody and parenting time is temporary and without prejudice and reserved until receipt of Dr. Wooten's report?
We have the report, Your Honor, already. That's the problem.
Okay. Okay, so does someone, because based on that report, someone wants to have a hearing on custody and parenting time, is that correct?
Yes, I'm going to be
Okay,
filing
why
a
don't we just set a
motion.
hearing then? The parties can get divorced in 2025.
We had the mediation and we agreed to reserve custody and parenting time, Your Honor. So I don't
Okay.
know why.
Okay, let's set it for hearing now. Let's set a trial date? I mean, I don't know if we're going to talk with Godfrey. I thought there were some parameters, but if there's something new in Dr. Wooten's report, then I guess either party can file a motion. We will conduct a hearing. So should we just schedule a hearing today, sometime in January or February?
I'll be filing a motion to release the report to another expert. So I need to get that motion to you. My intent was to get that motion filed once this judgment of divorce was in.
Okay, well, if we can't resolve this issue, we cannot enter the judgment of divorce. I thought the parties wanted to be divorced in 2024. But if you want, I'll give you a hearing date, and we'll address at a hearing date for a couple of days of a trial. You can bring in all your, if you're going to depose Wooten, if you'll appear for a trial, and we can put some finality to this issue of custody and parenting time. I thought the parties, this court's opinion, the parties should share joint legal custody. Don't worry about physical, it's just joint legal with parenting time. I have not read the full transcript, so I don't even know what the issue was, so I'm not really prepared to address that. I don't recall exactly what the agreement was of the parties relative to custody and parenting time on a temporary basis.
They do a 223, Judge, and they have been since June of 2023.
So it's just a parenting time issue then. Unless there's something new that's been brought to the party's attention by Dr. Wooten. One party's got some psychological issues or problems.
There's some issues with Dr. Wooten's report, Your Honor, and the motion is requesting the release of the report to Dr. Gunsberg, who is an expert, who's going to be reviewing the report. She would be our expert. And I'm sure Ms. Zagorski is going to use Dr. Wooten. I'm assuming.
I hate to see the parties continue to incur significant expense. And it sounds like the 223 has been working. And that was a temporary arrangement. Is that correct? It was a joint legal with a 223 parenting time schedule. Is that what the agreement provided for?
Yeah. Back in June of 2023, Judge, we did a 223 schedule, joint legal, joint physical.
Your Honor, there's been ongoing issues with respect to what's occurring with the minor child. And
I don't know of any. My client
Yeah.
doesn't know of any.
the minor child is has ongoing play therapy, as well, Your Honor.
That was agreed to. I think my
Yeah.
client requested it. It's been very successful and effective.
Well, we debate there's things occurring, that we believe bear on custody as well, Your Honor.
Judge, my
Okay,
client
so
is
you can
gonna
file a
be-
motion then, Mr. Chappell, you file a motion to modify custody?
Well, that's where, but again, as Ms. Kuhn indicated, we will have an expert witness, but we need to have that report released. I mean, I suppose if we could agree, if everyone would agree to to a stipulation that we could file after the hearing today to have the report released, that would expedite it.
This is the first I'm hearing of it, Judge, and I would ask you to remember this when you consider my request for attorney fees. My client just wants to be divorced and he wants his child to be healthy and happy.
Can we accomplish entering the judgment and then reserving your right to file a motion to modify, Mr. Chappell?
Yeah, we believe, obviously, we believe that it's important to have the reservation language that we agreed upon in the judgment.
It wasn't agreed upon. It was the judge's language. The parties never assented to it. I would propose this. We do temporary and without prejudice, and either party's right to file a motion is reserved. How's
How about
that?
that? That seems covered, Mr. Chappell. Repeat that again,
Okay.
Mr. Gorski, that that custody parent time be temporary without prejudice.
Either parent, either party's right to file a motion to modify it is reserved.
Well, what's wrong with the language? I mean, here's what we have, Judge, okay? I mean, it's a matter of where it's placed. The parties, what we've proposed is the parties agree that the issue of custody and parenting time are reserved, period. And then we go on to state that temporarily and pending further order of the court without prejudice, the parties shall share joint legal and joint physical custody of the minor child.
We don't agree that custody and parenting time are reserved, Mr. Chappell.
How are they not reserved?
I will agree that
What have we concluded?
file a motion is reserved. I do not agree that we reserved custody and parenting time. I don't agree with that.
What have we concluded in the realm of custody and parenting time, Ms. Zagorski?
That they're temporary and without prejudice. That's what Mr. Godfrey read into the record, and that's what the parties stated they agreed with under oath. They said yes.
And that's what we have in the judgment.
And you also have that it's reserved. And my client never agreed to that. I agreed when the judge asked the question, but that is a different animal than the parties agreeing to that being a part of their judgment of divorce.
Well, I think if you had an issue, it would have been raised at the time the judge asked the question and you would have said, no, Judge, I don't believe we're reserving it.
Well, I'm sorry, but Mr. Godfrey stated something else. The judge wasn't reading the parties' agreement into the record. The judge was asking a question. I
It's the
didn't bind
predicate.
my client by answering the judge's question. He wasn't under oath and he didn't say yes. I did not bind him to that.
You
It
did
was the
bind him to
predicate.
that.
I did not.
It was the predicate of the agreement.
Well, we don't make agreements based on predicates. We
We sure do.
based on the language on the record.
Where
That
the
is
court,
language.
the court would agree, this court's use of the word reserve was perhaps inappropriate. I was just prefacing the commencement of calling this case. But I noticed on page 5, when the court asked Mr. Godfrey to state here in the record, he first of all starts out stating on page 5, temporarily and pending further order of the court and without prejudice, the parties would share joint legal and joint physical custody. So that is the language that the court will adopt in this judgment. We don't need to put the word reserved. If the court has no objection to Mr. Gorski, including that additional language about the parties' right to modify custody and parenting time is reserved. I don't know, I didn't write down exactly what you suggested, Mr. Gorski, but that gives them a little bit of opening.
Yeah, Judge, I don't intend to file a motion and this court has jurisdiction over the parties. If they believe that custody and parenting time are properly changed, they'll let you know how and why.
Your Honor, then we don't have an agreement because Mr. Godfrey spoke to you, told you that we were doing this, we were reserving custody and parenting time. When we mediated, we were not going to do anything different with the custody and parenting time during mediation because we didn't have the report. Now that we have the report, there are issues. There are continuing issues. We did not agree that we would just say it's just temporarily and without prejudice. We wanted the issues reserved.
Okay, whereas Mr. Godfrey never used the word reserve, but in any event, what if I get Mr. Godfrey on the phone right now? Do you have a few minutes? See if he's available to zoom in?
Yes.
Let's call him from the bench, see whether he's available. Hi, Tammy. Mark Brown, like he's still available. Yeah, I just wonder if you can zoom in. I got the parties in court relative to the Mansik and Devout matter. Kim Kuhn, Eric Chappell, Maria Zagorski, trying to finalize some language in the judgment. And I thought if by chance he was available and he could zoom in, and he perhaps could join the discussion. Okay, but yeah, when he can finish it. Yeah, that'd be great if he could. All right, thank you. Thank you. All right, bye. Bye. Mr. Godfrey is on the phone, but someone's gonna hand him a note and they think he'll be available to join in on the Zoom. While I'm waiting for Mr. Godfrey, Mr. Chappell also suggested, or somebody suggested pages, now at 5, but 17, 18, and 19 of the transcript also addressed the issue.
Yeah, I think those are all financial issues, Your Honor. If I could, while everyone is on the line, we knew that apparently something was happening at 3:15 with the court, Your Honor. We were concerned about Zoom. But there was one other issue I'd like to raise. It's a small issue. On page 8, Maria, under personal property, the parties had established a date, Your Honor, by which they would provide Attorney Godfrey with any lists regarding personal property. We extended the other dates that relied upon the judgment being entered. I think that date should be extended as well. Maybe we give them like 30 days after the entry or something.
It already was. Kim made that change already and I approved.
Okay, all right. It wasn't on mine, so.
And you've made that, so we're working off the judgment that Ms. Gorski prepared.
Well, we were
Okay, Mr. Godfrey is zooming
we were
in.
working off of the first objected judgment, the one that Kim prepared in response to my judgment. And now there's a third one, which changed things again. So it's getting a little confusing, Judge.
We have that if the parties are unable to agree as to the division of their personal property, they shall request an arbitration with William Godfrey on or before January 31, 2025.
I did send you the transcript, Bill. Tammy has it.
Right. For the record, Attorney William Mediator Godfrey is present. Thank you, Mr. Godfrey, for short notice of zooming in. And the matter is before the court this afternoon on the defendant's objection to entry of the proposed judgment. Mr. Gorski is present representing the plaintiff, of course, and Ms. Kuhn and Mr. Chappell are present representing the defendant, Rebecca Devout. And the issue appears to be they have received Dr. Wooten's report. We may be having a motion filed relative to custody and parenting time. The issue is that Ms. Gorski, your language on page 5 of the transcript, you have a copy of that. You indicated that temporarily and pending further order of the court and without prejudice, the parties shall share joint legal and joint physical custody.
My notes, Judge, indicate that the custody arrangement is, quote, temporary, close quote, and, quote, without prejudice, close quote, to either party. I can indicate the reason why was we had not yet received Dr. Walton's report. And we had adjourned, I mean, this was our third mediation with the parties. And no one could give me an idea when we would end up with that report. So my thought process was when you get the report, file whatever actions you need to do dealing with the custody matters.
Your Honor, if I may, Bill, do you have a copy of the transcript?
Tammy is not. I mean, I just.
Okay, I understand. I mean, because there's and I know, Your Honor, you referred them to page 5, but when we came into court, the issue, I'll wait for him to come back. It was our intention to reserve the issue of custody and parenting time. And that was the first thing that was addressed when we appeared in court. And I'll just read it since you don't have it, line 20, the court, Mr. Godfrey has informed the court that the parties have reached an agreement on all outstanding issues with the exception of custody and parenting, and wish to reserve that issue until receipt of Dr. Wooten's custody and parenting time evaluation. And then both counsel, Ms. Zagorski and myself, were asked if that was correct, and we both indicated correct. We believe it is important to include language in the judgment of divorce, which indicates our understanding that the issue of custody and parenting time was being reserved. We have no issue saying that, you know, we have no issue saying that that we put the temporary language in there. But on page, that was from our perspective, that was the predicate of the agreement, is that the parties were reserving the issue of parenting time and custody.
And Mr. Godfrey, I have no idea the content of your conversation with the court when you called the judge and told him that we had an agreement and we would be putting it on the record. I don't know whether you said that that custody and parenting time were going to be reserved or not, but the judge stated that was his understanding. And your letter to us and the transcript reflect you stating that it was temporary and without prejudice and not reserved.
That's correct. Mr. Godfrey and the court did not discuss anything in detail. The court, perhaps, as I stated before, perhaps inappropriately used the word reserved. I just knew that it was not a final agreement on custody and parenting time. That's all I was trying to say. So I perhaps inappropriately used the words. Mr. Godfrey did not use the word reserved, Mr. Chappell or Ms. Kuhn. So Mr. Godfrey, that seems to be the rub here in the issue.
Well, Judge, I think on page 5, I indicated that if they wanted to bring up topics or issues with the children going back 2 years, 3 years, or whatever, they could, which I don't know what I mean, I wish I had Wooten's report, or if the parties were disagreeing with Wooten's report, but we had been pushing it and pushing it out. I don't know what else to do in those circumstances.
We just want to make it clear that we're not precluded from raising any issues whatsoever, because none of us had that report. We don't want there to be an argument made down the road that when this motion gets filed, that there's some preclusive effect from the judgment. That's why we felt the reservation language was important.
I've agreed to language that says that. It was included in my original judgment, which says that the judgment shall not operate as a bar to issues that preceded it.
In addition, though, the concern is that I also don't want the argument, and this is why I wanted it reserved as well, that the parties have been exercising this parenting time arrangement for a long time now, and that precludes any argument that a motion to modify or to change is not appropriate. There is case law that does allow for the parties to have temporary agreements, reservations by agreements, and the court has upheld those. I have case law. My concern is I don't want to have an argument or see an motion from opposing counsel. This arrangement's been going on since 2023, and no, court, you just need to deny this without an evidentiary hearing because this is what the parties have done. We don't want to be denied an evidentiary hearing. That's why reserving it was important. That's why when the court stated, okay, it's reserved, we were good with it. That was our understanding.
What about the language that custody and parenting time is temporary and without prejudice, reserving the right to seek modification upon receipt of Dr. Wooten's report?
No objection.
Reserving the right, but
Reserving the
then
right to seek modification upon receipt of Dr. Wooten's report.
So now we have the court speaks through its order. So now we have an issue where someone can raise that, you know, the reservation is the report. And we made these decisions. And so what can come in, what can't come in?
But the reservation was the report, Mr. Chappell.
It is not. You got to look at page 5. You have to look at page 5. Bill made it very clear that we could bring in anything.
Bring up matters or actions or acts that they think is important that predates any part of that agreement.
Correct.
there is case law out there that states a temporary arrangement can just basically become the permanent arrangement. That's what I'm trying to avoid. I don't want to have an issue on appeal because the language in the judgment didn't encompass what the agreement was. The agreement was that once we got the report and we looked at the report, if somebody wanted to file a motion, they absolutely could, and it wouldn't bar any evidentiary hearing, and that the longstanding arrangement of the parties would not in any way persuade the court to continue that. That's why we wanted everything to just be reserved. So that's my issue, Your Honor. If it goes up on appeal, that would be the issue. That's why we wanted everything reserved. We talked about no proper cause, no change of circumstances, the ability to automatically have an evidentiary hearing on this matter, not convincing you that the longstanding arrangement isn't appropriate. It was to be able to go to hearing if necessary. So that's what I'm concerned about. And that's why I think the language in the judgment needs to ensure that the parties have that ability. Because yes, I am filing a motion. Yes, I'm going to be asking to release the report as well as Dr. Wooten's notes, his test results, everything to our expert.
But
So
here's the problem, Judge, I think she just put it on the head of a pin. The bottom line is that they want a custody hearing. But what we agreed is found on page 5 at line 15. The parties would stipulate and agree that Dr. Wooten's report would be sufficient for any party. Not anything, Dr. Wooten's report. That was the agreement. And I now understand what the controversy is here, is that counsel is trying to get in the back door and create an agreement where none existed. We agreed that Dr. Wooten's report would be the basis, not Dr. somebody else, not their expert, Dr. Wooten.
So you're ignoring the rest of the language on page 5. And Bill even said that we can go back 2 years, 3 years, they can bring up anything they want involving parenting time, custody, etc. So, I mean, that this is the very issue that we are concerned about, Your Honor, because there will be an attempt to limit it. And it's very clear from what was put on the record that everything was open. Everything.
Neither party is prevented from bringing up those matters in the context of Dr. Wooten's report. That's what it says.
It does not say that.
does not.
Start at line 15 and read to line 20. No, read to line.
So if they want to go back 2 years, 3 years, they can bring up anything they want involving parenting time, custody, obviously subject to what weight the court gives it.
But Dr.
Doctor's Wooten
Wooten's
report that we just don't have, and frankly, Judge, I'm tired of waiting for it. So we're going forward with what we've got. No one could have agreed that Dr. Wooten's report was the only act because we didn't have it. There's no way that anyone was limited from it because we didn't have it.
Dr. Wooten's report would be sufficient for any party to seek a change in parenting time. Dr. Wooten's report, that's what we were waiting for. That is the nexus to a change in custody.
We did not have Dr. Wooten's report. We didn't know what it would state. As Mr. Godfrey had stated, we moved forward and reserved issues, made the custody and parenting time as temporary as we could, because we didn't know what we were doing with custody and parenting time. We did not have Dr. Wooten's report. We have Dr. Wooten's report. We don't have a judgment entered. I don't want an argument that Wooten's report was the end all of it. In fact, I have to have an expert to refute or to look at Dr. Wooten's report, because Dr. Wooten, I'm sure Ms. Zagorski's going to put him on the stand. It's common sense, Judge. If there's an issue with the report, if Dr. Wooten did not properly do something, or if there are issues and concerns that things weren't done, the court needs to hear it. And we didn't have that information at the time we mediated custody and parenting time, and that's why we wanted it reserved, temporary, without prejudice, with the ability to have an evidentiary hearing. Once we received the report, we were able to evaluate it, figure out what it did or didn't do, if there are any issues, and there are issues, as well as other issues, Your Honor. That's the also, as Mr. Chappell had stated, that's why we didn't just limit it to Dr. Wooten's report. There are other issues going back. We kept it wide open.
I think we're better off to set a trial. Let's just set a custody parenting time trial. Obviously, if this 2-2-3 schedule has been going on for the last year and a half, again, we'll give you a hearing, even though there may not be a sufficient change of circumstances under Varka, but it seems to be working to the court. There's been a lot of issues. Obviously, that Wooten report was meant to just to assist the parties and reach their own agreement, but obviously if they cannot, let's just set a custody and divorce trial, and we will hold off entering the judgment of divorce till sometime in 2025.
Your
Mr.
Honor,
Godfrey, do
we
you
had
have
actually-
suggestions? I don't want to waste any
Yeah.
more of your time. I know you spent 3 mediation sessions with the parties, and I thought we had a framework of an agreement, but we don't, and I guess rather than going back and forth, let's just set a custody and parenting time trial. Ms. Kuhn, you want to hire another expert, is that correct?
Yes, Your Honor, and I need to release the report and I need, I was gonna file the motion, with the order, allowing Dr. Gunsberg to get the raw data for the testing results, the notes, all of the documentation that had been provided to Dr. Wooten, and to release the report to Dr. Gunsberg.
The parties are not, the parties going to perhaps reconcile, they don't want to get divorced. I know the intent was to get divorced in 2024. For tax reasons, I don't know if there was tax reasons, other reasons why they wanted to conclude this matter this year.
They've been filing married, filing separate anyway, Your Honor, and they're not
Right.
reconciling.
All right. Do you want to just, we'll adjourn this matter without date? Ms. Kuhn, if you want to then go ahead and file your motion, and then at that time, Ms. Zagorski can respond if she gets involved in the case, and then at that time, the court can set the trial date on the issue of custody and parenting time. Until then, the joint physical with 223 will continue until further order of the court.
Thank you, Your Honor.
Thank you, Judge.
Anything further, Mr. Godfrey? Do you have any suggestions? I don't know. I don't think there's any purpose served with you meeting with parties any further.
I have not seen Dr. Wooten's report, Judge, so I don't know if there's anything I can do after seeing that to help the parties.
All right. Anything further then this afternoon, Ms. Gorski, Mr. Chappell, Ms. Kuhn? I'm open to any suggestions.
Not at this time, Your Honor. Thank you.
Thank you, Judge.
All right. Thank you, Mr. Godfrey, for zooming in at short notice. The court appreciates it.
Thank you.
Yep, thank you, Bill.
Thank you.